they don't have sufficient knowledge to answer the standard forms of inquiry in order to provide sufficient reps and warranties. So in order to plug those gaps, they are relying on legal indemnities to a greater degree in order to get best possible return on that bad asset. So types of insurance, now I've split this down into standard and non-standard, but of course, as with most things, it's not always as straightforward as that. Standard risks are probably what you'd more associate with title insurance typically. Now, we're trying to get away from that phrase because now our cover goes slightly beyond that. So for example, for title insurance, you'd look at restrictive covenants that we see an awful lot of, chance of repair, access, etc. Non-standard would be those that you wouldn't typically associate with title insurance, so you may use cover if your local authority search is delayed or you haven't got one, for example, building regs and planning, and even village green registration that is on the screen there. Now, possibly that is more geared up for a commercial transaction, but we are seeing that some pretty astute investors are buying up small strips of village green with the view of charging residents licences to cross it, because we can't actually acquire any rights by prescription with village green. Okay, going to go into the case studies now, and starting off with restrictive covenants, although I'm not going to go into the law relating to covenants, as I'm sure you're well versed with it, and it requires a session in itself in order to adequately cover that topic. However, it is a good means of describing how, as underwriters, we approach risk and assess risk. So with all cases, we assess the legal and the practical position. So if we look at restrictive covenants, the legal position is that does the